and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their final argument. Following the arguments by the attorneys, the court will instruct you on the law that is applicable to this case. After the instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of this case until you have heard all the evidence, the arguments of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, please notify one of the bailiffs who will notify me. During the course of the trial, the court will take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss this case with anyone, nor permit anyone to say anything to you or in your presence about this case. If anyone attempts to say anything to you or in your presence about this case, tell them that you are on the jury that is trying the case and ask them to stop. If they persist, leave them at once and immediately report the matter to a bailiff who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about this case or to communicate with anyone about this case or the people involved in this case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure that your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room, and you cannot have in the jury room with you any cell phones, computers, or other electronic devices. We actually collect them before you begin deliberations. We keep them for you out here. We give you a contact number in case someone needs to contact you in the case of an emergency, and we can receive those messages at that number and deliver them to you. And we'll provide you with that contact number when the time is necessary. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So, do not let even the closest family members make comments to you or ask questions about this trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, You must not talk about this case by using any electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. You may wonder, what are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for this case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find, and that is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters of law and other matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. I think you've been given notepads and a pen. If you would like to take notes during the trial, you may do so. On the other hand, of course, you're not required to take notes if you do not want to. That is left up to each one of you individually. We have provided you with a notepad and a pen for your use if you do wish to take notes. Any notes that you take will be for your own personal use. However, you are not allowed to take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed, and no one else will ever read your notes. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as an aid to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. And ladies and gentlemen, whether you're going to take notes or not, if you would please just write only your juror number on the top of your legal pad on the first page so we can identify which seat it belongs to. And don't write your name, just your juror number.